available to the tables to the right of the audience. This meeting is being recorded for the public record. Because of this, we request that personal conversations are kept to a minimum and cell phones are set to vibrate with any phone calls taken outside the chambers. If you are interested in commenting during any public hearing, please sign up on the sheets located at the tables to the right of the audience. When your name is called, please step forward to the podium, state your name and address for the record. Please address your comments to the board and not to staff or the appellant. Your comment should relate directly to the case at hand. We do understand there may be several persons who wish to speak. The chair may therefore impose a time limit for each person. Federal law requires the town make available to all attendees a Title VI public involvement survey. These surveys are on the table at the right of the audience. Members of the public who wish to complete this survey may do so and place them in the designated area. If because of a disability, any person in attendance needs assistance or accommodation to fully participate in this meeting, please notify staff. Thank you for your assistance in facilitating a respectful, fair, and timely meeting. Again, welcome to our meeting. Please stand for the Pledge of Allegiance.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Can we take roll, please?
Paul Gugelberger.
Here.
Ann Inman. Here. Catherine Ransberg. Here. Marcy Tashler. Here. Marcus Turner.
Here. First item is approval of the minutes. These are from February 18th of this year. Is there any discussion? Any corrections? And if there are none, we'll entertain a motion.
I move that we approve the meeting minutes of February 18th, 2025 as submitted.
Second.
A motion by Mrs. Ransberg and a second by Mr. Guckenberger. Any discussion? All in favor, say aye.
Aye.
Anyone opposed? Minutes are approved. Move on to requests for continuances or agenda modifications. Paul?
Thank you, Chairperson Turner, members of the board. Staff would draw your attention to the two petitions on the agenda, SE 2405 and VAR 2407 at 7893 East US Highway 36. As I'm sure you're aware, these have been continued a few times. Petitioner is requesting an additional continuance for 2 months to your June 17th hearing. Without getting into too many details, these cases do involve a property that has an outstanding issue that needs to be addressed from the prior approval at the Lowe's property. The petitioner is not the property owner, so there has been discussion with the property owner and the petitioner. We are hopeful that they're going to make some proposal before the June hearing that staff can consider, and hopefully that we can come forward and have the matter heard at that time. So staff is supportive of additional continuance request that would be without additional published notice, but it would be with mailed notice by the petitioner, and again to the June 17th hearing.
So this request for continuance is because of things that are happening that are beyond the petitioner's control. Is that,
Yeah,
would that be a good way to say it?
Yes, that's fair to say. It involves, certainly it involves an issue that the property owner, Lowe's, has as an outstanding obligation that the staff feels should be addressed before there are any additional approvals at the site. So the petitioner is obviously working with the property owner. Staff has had conversations with the property owner and the petitioner, and at this point, we're just waiting for a proposal to come back from the petitioner and the property owner on addressing that obligation.
So how many times have we continued these cases?
I believe this has been continued 3 times. It was originally docketed in December, continued to January, then continued to February, and then continued to today.
So how many times can they request a continuance?
I believe your rules of procedure allow you to grant It's within the board's discretion to grant as many continuances as they believe are reasonable. They're only entitled, I believe, to one by right, but you can continue it, I believe, as many times as you find to be appropriate.
And have all these continuances been because of the issue with Lowe's?
Correct, yes.
I think that we ought to give the continuance because we're going to have to revisit this over and over again with other businesses unless we see this one through.
I agree with that, but it is concerning to me that we've got a third party who is interfering basically with the business of the town, because they're either not, I don't know if there's contentious negotiations happening or they're just dragging their feet and not being timely in providing response. But it bothers me that we've got an outside party who's not part of this proposal who is causing all these delays. I don't know what the solution is, but it's bothersome.
And just to follow up, so if we get to June and things aren't resolved, then we're still in the same situation, is it fair to assume that we would be seeing another request for continuance? Is that helping you to continue it, or would it help to not continue it? And to say like June, we want you to come and present, how would that help staff? Because, you know, you're the ones that are working on this.
Yeah, so staff's position is that we are supportive of continuing at this point because we do think there's been some progress made, however slow it has been. So we think there's an opportunity to resolve an issue that's been outstanding for many years, absent the town taking legal action. So if we can come to a resolution that's agreeable to both the town and the property owner without a legal action, that's always beneficial. And if we come back in June and we haven't made any additional progress, you know, we might provide a different recommendation on a continuance at that point. But since we have seen some progress made, we think it's beneficial to continue it and hopefully make more progress.
All right.
I move that we continue SC 2405 and VAR 2407, 7893 East US Highway 36. Excuse me. A special exception to allow for a drive-through facility within Tier 1 of the US Highway 36 overlay and a variance of development standards to allow for drive-through components to be located within the front yard along US Highway 36 to the June 17th, 2025 hearing without additional published notice, but with mailed notice to be sent by the petitioner.
Motion by Mrs. Ransberg. Is there a second?
I'll second.
Second by Mrs. Inman. Any discussion? Roll call vote, please.
Guckenberger,
For.
Inman, 4, Ransberg, 4, Tashler, 4, Turner.
4. We'll move on to public comment. Would anyone like to speak? I got nothing either. So with no one coming forward, we will close public comment at, looks like 6:40. We have no old business. We have no new business. We're going to go into our training session.
Guys for coming tonight just for the training. Yeah, much better. All right. Thank you guys for coming tonight. So tonight I'm just going to go over some training. The purpose of training is obviously to prepare you guys for the cases that are going to come before you. I've given you guys some written materials. A lot of this for a lot of you is going to be review, but we did have more than ever new cases at the Court of Appeals level this year, so some of it will be new and some of it will be review. So if you guys will turn to page 2 of your materials. So the most important thing I think to remember is when a case comes before you, just to ask yourself, what kind of case am I hearing? You guys hear 4 different kinds of cases: administrative appeals, variance of development standards, variance of use, and special exceptions. So you'll just kind of say, what kind of case am I hearing? And then you can kind of go through the different factors that you'll be considering. The first case, the first kind of case you hear, administrative appeals, is where you guys get your name. Board of Zoning Appeals is also the least common kind of case that you hear, but it's still very important and often the most interesting kind of case. There's potential for you guys to get them every year, so it's always good to remind yourself what those are. In these cases, it's whenever an appellant, someone that's aggrieved by a decision of your staff, wants to come before you and ask you how either the zoning ordinance is interpreted or what it means or how it's being applied. So in these circumstances, your staff is often administering your UDO. They're issuing permits, they're issuing violations of the code, and they're telling petitioners that come before you and the Plan Commission, this is what we think the code means, and this is how you're going to comply. If they ever disagree with that decision, even if it's not the petitioner, it may be the community at large. Anyone who's aggrieved has the right to come before you and have you guys have a hearing on that. Your review is essentially saying, is our staff correct in their determinations, or are they not correct, or are they partially correct? So in those circumstances, the staff will present their side, the appellant will present their side, and then you guys will have a discussion and you'll issue findings. So in this case, you can say, yes, they're right, no, they're wrong, or they're kind of right, they're kind of wrong, and this is what we think the case is the outcome should be. So we have some examples. I'll kind of touch on them briefly. The one we talk about all the time that happened here was the Badass Coffee case. This was when they came for a sign permit. It was a coffee shop that had like a borough on it, and members of the community thought that the name of the business was profane. And so our administrator had to make a decision as to whether that was obscene or whether it was not obscene. And there was disagreement as to that. So it became an appeal where the Board of Zoning Appeals had a discussion as to whether that the name on the sign was profane or not. And so that would be an example of something, a decision you might have to make in an administrative appeal. If you go to page 3, this is a City of Noblesville case. This is about billboards. Many jurisdictions, especially in Indiana, have pretty much outlawed billboards, but there's a rule essentially that if you have one already existing, you can't force them to remove it. So that's called legal non-conforming status. In this case, a storm came through, destroyed the billboard, and they had to repair it. In doing so, they rebuilt it about 3 inches away from where it was originally built. Staff came out, said that you relocated it, you lost your non-conforming status, and therefore you can't have your billboard anymore. Billboard company appealed to the Board of Zoning Appeals, which affirmed the decision saying, yes, you relocated it, you lost your non-conforming status. This went all the way up, and the court had to decide was that slight movement a move or was it a relocate? And so the simple question is, what does the word move mean and what does the word relocate mean in the context of City of Noblesville's zoning ordinance? In this instance, the court said since they didn't define move and relocate in the ordinance, that slight movement isn't enough to be considered a relocation, and said that sided with the billboard company. The takeaway from this is, if you run into issues with your UDO, it's important to be clear as to what the UDO intends. That's more on obviously the town council, Plan Commission side, but this would be something that would come before you where you're deciding what those words mean. A new one this year is the Greenfield Avenue Properties case. This was out of Noblesville. This one dealt with a drug rehabilitation and job training facility for a conditional use permit. In this case, it was a church that was operating or wanting to operate this facility. The Board of Zoning Appeals denied the permit, and the church appealed, saying that the denial of the permit infringed on their First Amendment right of free exercise of religion. The Board of Zoning Appeals affirmed the staff's decision, and it was appealed to the Court of Appeals. The Court of Appeals ultimately said that the denial of the permit did not infringe upon their ability to exercise their religion, even though they contended that it did. And part of the reason I bring this decision is not only to show you this would be an administrative appeal case, but also there's going to be 3 cases in your materials that touch on this exact subject, which is drug rehabilitation centers coming in. It's extremely popular all over the state of Indiana. We have tons of cases on the Court of Appeals level right now. A lot of appeals are being made. So I just want you to be kind of familiar with this issue because it's going to be coming before you, both on a First Amendment issue, Fair Housing Act, those sorts of things. So just want to point that out to you.
And this is a memorandum decision, which means it can't be cited.
Yes.
But can we assume that there is a lot of underlying case law in this decision that can be cited to support the opinion?
Certainly. We provide you with the memorandum decisions. Usually these cases aren't used as, they're not cited by other courts in Indiana, but they're instructive because if we were to go to a trial court or a court of appeals, they're still going to rule on our case regardless. And so we can kind of get a sense on how they're going to rule, how they're thinking, even if that case isn't actually something that can be cited before the court.
But this is setting a new
Precedent. It is not, no. It's just informative, not precedent.
Okay, thank you.
Yes.
Could they appeal this?
Yes, they could, yes. Not that I know of, no. It could get appealed to the Supreme Court of Indiana, yes. I don't know if certiorari has been denied. I haven't looked at that, but I don't think so. Okay, so the next type of case, the most common kind of case that you get is going to be the variance of development standards. This is when the petitioner is asking for relief from your development standards. Often we see setbacks, building height, those sorts of things. For this case, this type of case, we have our factors, and the two I want to touch on first is practical difficulty. As you guys know, we changed our UDO this year to add new factors for you guys to consider, but we still have our original 3 from Indiana statute. Just kind of want to review what practical difficulty means because sometimes it can be a little confusing. Practical difficulty, just generally the courts interpret practical difficulty to mean that the strict application of the UDO will cost more, a lot more. So it'll cause significant economic injury. That's what we really break it down to when we think about practical difficulty. It's the lesser standard in comparison to unnecessary hardship. Some examples are, if we have to comply with the UDO, we're going to have to move the whole house. It's going to cost $75,000 when instead you could just grant us a setback variance. That could be an example of significant economic injury. You're also looking at other things, though. You're looking at, did the petitioner, or in your UDO, a former property owner, cause this issue in the first place? You're looking at that. And you're also looking at, is there any other alternative? Could they have thought of something different that could have negated their need to come before you and ask for a variance of development standards? So I've kind of got some bullet points for you here that you could kind of ask yourself that these are questions that courts ask straight out of court cases. Is the difficulty more than insubstantial? So do they have to be coming before you? Is it just, do they have to just pay to comply with your ordinance? Or are they going to pay a lot more to comply with your ordinance? Is it the minimum necessary to make reasonable use of the land? So when they're coming before you, are they asking for everything under the sun? Or are they asking for just exactly what they need to achieve their purpose, which is to make use of their land? Is there anything special about the property or the circumstances of the case that was created by the owner's own action? And then can the applicant, can they figure out something else? Can they find another feasible alternative that would negate their need to come before you and ask for a variance? So these are just some questions to ask yourself when you're going through the cases and saying, hey, I'm not sure if it's a practical difficulty or not. These are just some questions that you can ask yourself.
So Anna,
Yes.
so when you're talking about costs,
Mhm.
does it cost more or a lot more? I mean, that's a matter of perspective, right? It's like, well, what's a lot more? $100 could be a lot more to a person, or
Yes.
10,000 could be something that, it's like, that's a lot more. I mean, I think we had a case about locating a pool in the side yard or in the backyard. Costs a lot to put in the backyard. And we heard that, so it's still in the side yard, but then can it be as wide as they wanted, or did it need to be narrow? So, I mean, so cost, how do we come to the point where it's a lot more? Because I'm like, hey, $5,000 may not be a lot more.
Yes.
Any advice or guidance on that?
And I wish I could provide you advice because obviously it's always going to be different. I mean, what is a lot of money? It's constantly changing and it will depend on the petitioner that comes before you to some degree. But I think it's going to have to be discretionary to you. I think when you see it, you'll know it. When they're saying, hey, it's going to cost us hundreds of thousands of dollars for a simple issue that could be fixed with a variance, I think it will jump out at you. I think if it's a close call for you, then it may not be a significant economic injury. But I can't answer that question for you because these cases, I mean, I've seen courts say significant economic injury on under 100,000, and I've seen them say it's not enough for a large company when they come before them for $500,000.
Okay.
So I can't unfortunately provide you too much clarity on that, but it will just depend on the facts and circumstances of the case. You know,
Seems like we've got conflicting rules, because under practical difficulty, it says significant economic injury can be self-created, must be no feasible alternative. Feasible is a subjective term, to take Paul's point. But then under unnecessary hardship, case law says economic loss is not enough. And I feel like where we struggle is that economic loss is not enough. Doesn't matter how much more it's gonna cost you, you have to conform. We can't give you a waiver. But then we also have this that says significant economic.
Yes.
So
and
I feel like there are two conflicting rules coming out of these cases. One that says economic loss cannot be the only reason. The other one that says, yes, significant economic injury with
Yes.
feasible alternatives.
And I think I can clarify that to some degree. We put both, these are two different standards. So unnecessary hardship, those cases are saying you've met the practical difficulty threshold. It's going to cause you significant economic injury. That's not enough for unnecessary hardship, which would be your variance of use standard. But for a variance of development standard, we're looking at economic injury. So the cases are different because they're applying different standards. So for just development standards, we're just looking at practical difficulty. You're really focusing on economic injury when you're having a variance of development standards come before you. If it's a variance of use coming before you, you're looking at something entirely different, a much higher standard, unnecessary hardship, where you can take into consideration economic injury, significant or otherwise, but you also need to be looking at, can you put this property to any use without granting a variance of use?
So unnecessary hardship is the yardstick for
Variance of use,
variance of use. Practical difficulty is for
variance of development standards.
variance of
Yes, and we put them on the same page so you can kind of see, because these are your two standards and see how they're different. But as far as variance of development standards goes, we're just focusing on practical difficulty, so significant economic injury. And I will say, to some degree, it's nice. It can be assist you, and that it isn't a hard, fast rule on what is significant economic injury, because you have so much discretion on these cases that it's up to you to make that determination based on the facts ahead of you. So you're not trapped into just deciding, you know, there's no formula. So it can provide you some discretion in that regard.
So when we have those discussions, there's a couple things I'm thinking about is that, and I know we've had cases where we're discussing with staff about what's being recommended, maybe our perspective. The thing I would ask is that as we get into some of these, I always look for you to chime in when maybe we're going off course or delving into things that we shouldn't be discussing in that case.
Yes,
Because Dan has a way of giving a look
he does.
and saying, hey, you guys you're way off course here. So I'd ask that you jump in and bring us back if, you know, we're deviating from where we need to be. And I forgot my second point because I made that first point. I'll think he'll
Well,
come
let
back.
me know what it is, but
Okay.
certainly I'd be happy to do that. Okay, so if we'll move to page 4, I'll come back to unnecessary hardship to kind of keep them separated. We have your 5 factors now there. So the original 3 you guys normally deal with, but we've brought in that the variance requested is the minimum necessary, and the need for a variance is not caused by the owner, previous or present. So as we discussed in discussions of changing the UDO, these really kind of are part of the standard of practical difficulty, but this just makes it a little bit clearer for you. As I mentioned earlier, this decision is discretionary. It's always important. What kind of case am I hearing, and what is my standard of review? Discretionary. Even if you think that they met all 5 factors, you can say, I still don't think that this is best for Avon. As long as you have some kind of reasoning to back up your decision, then you're able to make that decision. You can ask what is best for the town and deny it, even if you think all of the factors have been met.
So, I mean, this was my other point. I know that we've been asked to make sure that we're discussing and making the points to the criterion and make sure we get that on record. And there's been some cases where I feel like we just jump right to the motion after hearing the petitioner and staff. And I guess you or Linda and Paula help us make sure that we've covered that, because I know Marcus has a couple times just gone in and said, okay, made sure we covered that to get it verbally on record, which, seeing the meeting before this meeting, does that I assume helps you guys, that verbal recording is something to go back and to show proof that things were considered?
Yes, I would always prefer you guys have a conversation before you make a motion, because one way to challenge your decision is that you guys had pre-decided. So you'd had some kind of conversation before. So how did you guys know that you didn't need to have any conversation? How did you guys all know that you agreed and took the motion? So I'd always like to have something on the record in the event that the decision was appealed, for example, by the remonstrator. Even if you vote for it, the remonstrators could say, why did you decide it that way? I have nothing to base on why you didn't talk about it. You didn't have any kind of questions for the petitioner. Even if you have a public hearing, you should always discuss the case, discuss the factors, ask questions of the petitioner. It doesn't have to be a long process, but just if necessary, you can say, hey, what do you guys think about practical difficulties? And someone will say, yeah, I think it's met for this reason. I mean, even that is enough, which is what the courts have said. Okay. I'll kind of go, conditions are for all of these cases, which you can impose reasonable conditions on this. I'll get back into kind of what we look for when we look for conditions. But you can also grant a variance different than the request. So if they come before you and say, hey, I want a 50-foot setback, you could say, I'm only willing to give you guys 40. That's totally fine. You guys have the discretion to curate the granting of a variance to what you think is appropriate. Okay, variance of use. This is a little different, and this is when we're going to get into the unnecessary hardship. So this is when they're requesting relief from your use table. And you might ask yourself, why would someone ask for a variance of use and not just rezone the property? And usually this is because there's small properties or small uses that wouldn't have a large impact on the surrounding area. So for example, this may be a hair salon in a neighborhood or a childcare facility in a neighborhood. That would be an example where we might not want to rezone that small parcel. We might want to just ask, can we use it for something different than we're using it for? And so for these sorts of cases, we have our 5 factors, but this is going to be our necessary hardship standard. So unnecessary hardship is the higher standard. So it's saying after we look at all of the facts together, the property can't be put to any kind of reasonable use unless we grant relief from the UDO. So this is a very, very high standard. It's essentially saying that the land can't yield any reasonable return other than what the UDO says that it can be used for. And so on page 4, if you go back a little bit, I've tried to put some bullet points in there. So at this, like you mentioned earlier, Catherine, this isn't just economic injury. This is economic injury, and can we not use the property at all anymore because we have to use it for what the UDO says it has to be used for. We're still looking at whether the owner caused this problem. We're still looking at whether this is the least necessary. But what we're really looking at is, can we not use this property at all because of the topography of it, the shape of it, the location of it? It's not just that it's located in this neighborhood or it's a part of this development. It's saying there's something really unique about the circumstances of the situation of the property that essentially, unless we grant relief, this property is not going to either develop or be used in any kind of reasonable way. It's a very high standard. Again, this is discretionary. Even if you find it meets all 5 factors, you can still say no if you can support your decision.
So on that one, how does that work? Because if we say no, it's like, hey, the evidence supports this and staff recommends approval and we deny it because we don't think it's appropriate. I'm like, how do we support that decision on record? Saying it's just not the right thing and we don't support that? We don't.
Yes. Yeah, you still could. I mean, even though, okay, for example, it may not be injurious to the public health, safety, and welfare, but it may cause an increased amount of traffic that isn't in the best interest of Avon. So you could still say it's not bad, injurious to public health, safety, and welfare. And no, it's not going to substantially impact property values, but I still don't think that this is the right use of this property at this time. So there are still other intents and different things listed in the UDO that the UDO is trying to achieve that aren't necessarily always captured in all the factors that you're looking at. And as long as you can look to one of those in the UDO and say, yes, the factors have met, but this is part of the thing. This is something we're trying to achieve through the UDO, through our land use policies. And I don't think that those are achieved by granting this, even though the other factors are met. So I would encourage you to just look through the UDO, especially the section that you're looking at for that use. Yes.
Just following up on that. just curious what your opinion is. Like, I understand that you can find all 5 factors are met and still deny something, but I always also feel like when you look at the first one, public health, safety, morals, and general welfare, that typically, it seems like to me, anything that you wouldn't want in the community, somehow you can make an argument there that whether it's public safety or general welfare, like, is general welfare just kind of what's best for the community?
Yes.
So
It-
is it better to, I guess I'm kind of asking, is it better to always, even though you could say, yes, all the findings are met, but we still are denying this, to probably, if there is a way to make the argument that one of the findings is met, that you're going to be on more solid ground if there were a legal appeal or something?
I would put it a different way. I think you're going to be fine either way, which is why I put this in here to give you assurance that you can make the decisions that you think are best. It's very rare that I don't think I've ever seen you guys find that all the factors are met and still deny it. So generally speaking, there's a reason that you guys don't want to approve it, and you usually say exactly why, and it usually connects to one of the factors because you guys hone in on the factors like you're supposed to. So yes, I would say if you don't think a factor is met, you should say that instead of saying they're all met and then find another reason. But it is possible to do so. Other Board of Zoning Appeals have done that before, and the courts will back them up. They back them up every single time. Okay, same for the other one. You can grant conditions for this, and you can also grant something different than the request. Okay, so the last kind of case you hear is special exceptions. So obviously in your use table, there are certain uses that are listed as only by special exception. These are usually uses by their very nature require some kind of oversight, a more intense look at the request, by request of the town council when they adopted the use table. The original for these is landfills. Yes, we know we need landfills, and we might need one in our community. We just want to really pay attention to where we're putting the landfill. That's essentially the really general high-level idea of why we would want a special exception. So obviously it has to be listed in the use table as a special exception, and then you have your 4 factors and 3 additional considerations. For this case, it is a ministerial review. So if you find that all 4 factors and 3 additional considerations are met, you must approve the request. For conditions, this applies to all the conditions for all the cases. We just put it here. You can require conditions on all of your approvals. However, the courts have said these are the 7 things we look at and whether they are legal or not legal for when you impose a condition. Nationally, we think about this as the nexus test. Lawyers use that in court cases all the time. We call it, there's a nexus. Are they reasonably related? So is what's being requested related to the condition that's being imposed? But really, you're looking at these 7 things. Is it constitutional? Is it within your scope of authority? Does it offend any other part of the UDO? Does it require the petitioner to do something illegal? Is it in the public interest? And this is kind of the nexus. Is it reasonably calculated to achieve a legitimate objective of the UDO? And it should not impose any unnecessary burden on the landowner. So in review of conditions, most cases are looking at permits. A lot of people impose conditions on permits, but even for other cases, some examples of what would be an improper condition could be essentially that you require payment of like a mitigation fee for granting a permit. That would be exceeding your scope. You guys don't impose mitigation fees. That's not within the Board of Zoning Appeals authority. So that would be an example. Or there aren't a lot of examples, but the goal is if they're asking for something, make sure that your condition is related to that request. So if it's for a setback, make sure that whatever the condition is trying to achieve is trying to mitigate your concerns as it relates to the request. It's not just tacking on, well, now that you're asking for a special exception or a variance, let me tack on these 7 other things I'd like to achieve in the meantime. Make sure it actually relates to the request that's being made. Okay, and we've put into your materials all the different things that you have for special exceptions. You guys have a lot, 69. So just being familiar, these are if you're going to get a special exception, it's going to be on this table. Okay, if you'll jump all the way back to page 10, art of making findings, as Dan likes to say. You're required to make them by law, so you might as well do a good job while you do them. So under A there, the most important thing is asking questions and asking the right questions. So as we kind of touched on tonight, figure out what your factors are and ask questions that relate to the factors. This is important because well, you might as well ask questions about the factors because that's what you're supposed to do is like figure out if they've met the findings or not. But also because petitioners can appeal your decision to the courts because they can say that because you asked all these other questions that don't relate to the factors, that you actually made your decision on all those unrelated things, and therefore your decision was arbitrary and capricious. So it makes our lives easier to defend you if it was ever appealed, if you guys talk about the factors, but also you just want to protect yourselves in that way. And the way to do that is just read your staff reports in advance and prepare questions on your own. Staff reports are great. They're a great starting point. You don't always have to agree with staff, but it's really important to know why did staff reach the conclusion they reached, and then say, well, I don't think they answered these questions for me, or I'd like the petitioner to answer these questions for me, and come to the meeting with those. And it'll kind of guide you through the meeting so we don't go down the rabbit hole in the meeting. Also, keep in mind that the petitioner has the burden to prove this to you. Just like in a court, the judge isn't going to make my argument for me or the other side's argument for me. They're going to expect you to make the argument, and if you don't do a very good job of it, that's kind of on the petitioner because they're asking for something, they should have to prove it to you. The reason I say this is often sometimes I see us we don't always ask questions of the petitioner, we kind of ask them of staff. And I still want you to ask questions of staff, but I do want you to if you don't think that they've answered a question, ask them, because that's the best opportunity for you to figure out what you need to know and for them to say, hey, I think I've met these 5 factors for this reason. It really is their burden. Okay, yes.
So I got to ask a question. So there's 2 that pop to mind that always come up, the drive-throughs.
Yes.
I always get that. And, what we hear is, well, everybody else has them. So basically it make reference that they've been approved in other areas. And, I think we've tried to make the point that no one case sets a precedent for a follow-on case, which is something that if nobody else says it, I'll always say it, because just make sure they hear that. And as this board would change, I would hope that they would feel and be given guidance that you don't have to do that. But then I also heard from maybe one of your predecessors that, well, you can't be arbitrary in how you make that decision. So I'm like, if we say we're not going to give you the special exception for that drive-through, even though we've done it all up and down 36, is that going to cause some sort of litigation that the town's in a bad position for?
No, certainly not. Every case is different. The facts of every case is different. The design of the project is different. It's always going to be different. It's very fact specific. And no, you don't set precedent with your cases. So in the event of appeal, yes, they could probably say, yeah, everybody else on 36 has a drive-through, but we would respond, but that doesn't matter because they didn't meet their burden of showing that they met all the factors. And so if you were to not grant a drive-through because they didn't meet one of the factors, that would be within your discretion to do so. They have to prove that to you. And so, yes, you can think about it. Yes, a bunch of people have drive-throughs, and we've talked about possibly amending the UDO to account for that. But every case is different when it comes before you, and the cases that came before you and the ones that come after you,
Okay.
doesn't matter.
So another case would be if an auto dealership came and said that they would need a 30-foot pylon sign to match other dealerships in the area, or it would cause them economic hardship.
Mm-hmm.
How, any advice on that? I mean, is that one where it's like, okay, is that truly something that would be a special exception that we would need to consider, or we question, does it really cause you an economic hardship or not?
So for that one, if they're asking for a sign, they'd have to prove to you what would be the significant economic injury is what I would have you ask them.
Oh.
And they would say, well, we have evidence that in our other businesses that have smaller signs, we make X less dollars every single year. That's what you would want to ask the petitioner. They can't just say, well, it's not fair, ours is smaller, we'll make less money. They're supposed to present evidence to you on how much money do they anticipate losing, and then you'll make a decision as to whether that is significant or not.
Okay.
Yes.
Yeah.
So, and that's, if you're not really sure, that's when you need to ask questions. Give me evidence, how has this worked in other jurisdictions? How has this worked with your other businesses? Are you really sure you're going to lose a lot of money, or are you just speculating that you will? Because you should not make decisions on speculation. You should always make decisions on the facts that are presented in the actual case presented before you on that day.
All right, thank you.
Mm-hmm. Okay, we're going to jump all the way back. We've got a lot of cases to get through, so I'm going to try to touch on just other things I have to remind you of. On page 12, conflict of interest. You guys are great at this, but just as a reminder, you cannot participate in a hearing if you are either biased or prejudiced, which would render you impartial, or if you have a direct or indirect financial interest in the outcome. Direct or indirect financial interest should be pretty clear. Obviously, if you're going to make money or lose money because of a case, you cannot hear that case. That's automatic. Bias and prejudice is a little bit tougher. And the courts have sometimes waited on this to provide a little clarity. But the idea is that you're always going to have your own opinions. You're going to have your own emotions. You're going to have friends. You're going to have family. The key thing is, do you think sitting and hearing that case that those relationships or feelings or emotions are going to impact your ability to be partial? That's the ultimate question you have to ask yourself every single time. Just because you're friends with the petitioner or the person that's going to be negatively impacted is not enough, is what the court has said. I remember in the case, the BZA president pretty much said, I'm friends with everybody in this group, and I might lose friends over this, but that doesn't mean that I can't be impartial, and the court upheld that. What's most important is not making statements prior to the hearing that would render you impartial. So if at lunch or even to your family members, you say, I'll never approve anything to do with apartments, all it takes is in a case that we subpoena them, we depose them, they say, yes, they said that. Now you can never hear cases again about apartments. So it's really the stuff that you guys say can come back to get you. So it's just important that if you really are impartial, if you really did feel that way, you wouldn't be able to hear those cases, and you should know that. Okay, let's jump back to, let's go all the way back to page 14. So this is about defending BZA decisions on appeal. If your decision was ever to be appealed, these are some examples. So we look at number 4 on page 14. This is the self-storage facility case. We've gone over this, and you guys actually cite it during your hearing sometimes, which I'm always proud of. But this is about the case where a self-storage facility came in making a request, and the other businesses in town remonstrated and said, hey, we have too much self-storage in our city, so can you please not grant this? And just as a reminder, it is not within the BZA's purview to regulate competition within the community. That is the market's job to do that. You're just thinking about land use. So we have too much fast food restaurants. We have too many car dealerships. We have too many banks. That's not
Chicken
your
restaurants comes to mind.
purview. Remember the statements thing, Catherine. I'm just kidding. So just as a reminder, you get this argument all the time. It's not your job to worry about whether there's enough or too few of a business in the town. Number 5, this is more for staff, but as a reminder, just to have petitioners always follow our own ordinance. This case was kind of surprising, but this was the big solar development up in Madison County. But essentially, the petitioner submitted like 13 of the 14 things that were required to build the solar farm. And the remonstrators came in and said, hey, I didn't get all the things I was supposed to get, all 14 things. So they shouldn't have granted this. And the court said that's correct. When they submit things to staff and to you, it's not only for your benefit, but it's also for the public's benefit. So just as a reminder, we have to follow our own ordinance. Okay, let's jump all the way back to the 2024 cases. I think it's on page 15. This is the most cases we've seen in probably 20 years, all on back to back to back. So pretty exciting year for the BZA. I won't go through all of these. You guys can review these in your free time, but I'll hit some highlights. So the first case I want to touch on is the Tipton County BZA case, Hope for Hurting. This is one of those examples I talked about earlier, which is drug rehabilitation centers. So in this case, our drug rehabilitation center came into a pretty nice neighborhood with their intent of having 2 or 3 people that were in drug rehabilitation live there. So they came to the BZA, and the BZA denied their request to do so. In most of these cases, they're denied, which is how we end up in the courts. In the hearing, the petitioner explained all the security measures they're going to have, the background checks they're going to require, the drug testing they're going to require, and they presented actual evidence that there was no effect on property values because of this. Remonstrators came in and said that they didn't want criminals in the area, they didn't want increased traffic, but most of it was speculation and opinions and fears, but there wasn't evidence presented, and the BZA still denied the request. And a reminder for these cases is not only do we have the First Amendment for the other case where there was a church asking it for their religious mission, but we also have something called the Fair Housing Act. So people who are suffering or recovering from drug addiction are by definition persons with disabilities that are protected under the Fair Housing Act. So we always have to keep that in mind and not make our decisions to not allow something because of someone's status as being in drug addiction rehabilitation. But the big takeaway for you really for this case is that the BZA found that the court found that the BZA's decision was not founded in facts, but on unfounded speculation. So in order to make a decision, make sure that you have substantial evidence to support your decision. So listen to the remonstrators, listen to the petitioner, and make sure that whatever decision you make, you're considering actual facts that are presented before you when you make your decisions. In this case, the court overruled and upheld the granting of the request. Okay, if we'll jump to the Monroe County BZA case, number C, or letter C. This is from my hometown, actually. So this is an issue where the lawyer disagreed with staff. So this was a request for a permit to operate a recycling center. There was nothing in the use table that related to this in this circumstance, so the planner made the decision that that sounded like garbage, so that was the use, the standard they permitted, and the BZA granted the permit. The lawyer later, when they were drafting the findings, thought that it was actually a mistake and that it should be not garbage, but scrap metal, because that's actually what's going to be happening at the recycling center. The BZA then, upon the advice of counsel, revoked the permit, and then that was appealed. And the court actually said, yes, if there's a mistake in law, you can revoke and go back and correct your decisions, which was kind of surprising. So even if we get something wrong and it's a mistake of law, you're allowed to go back and correct that decision, is what this case said. Okay, D, BZA can enforce obligations to construct sidewalks. Dana, I've seen this in some other of our clients' jurisdictions, but just as a highlighted reminder, this was essentially, the city was enforcing its requirement that the petitioner construct a sidewalk. We do this a lot here where we're trying to connect or build our sidewalks. And they said, hey, you really shouldn't be doing this through the BZA, through planning. You guys should do this through, a funding mechanism for public improvements. And the court said, no, if you impose a condition or they make a commitment to construct those sidewalks, we can go in and enforce that. So that's that. And that would likely be something that come up on an administrative appeal to you, just as a heads up. But just a reminder that you do have the ability to enforce those obligations. Okay, I'll skip most of the rest of these and I'm going to jump all the way back to I. This is another drug rehabilitation case. And this case it's pretty much up in the air right now, but this is one that went all the way to federal court and is still ongoing. It's been about 4 years that this case has been ongoing. But this is just another issue where the federal court, there was a denial of a variance for operation of a drug rehabilitation center. And the court said there's enough facts here that there's rights under the Fair Housing Act that we're going to kind of make the BZA make their arguments as to why they did not violate the Fair Housing Act. So just as a reminder that if we want to talk more about this in the future, and I can provide more information to you on this, but just as a reminder, this is important and this is going on right now. And the last one, a fun one, denial of a lighting permit. So this took place, this is a Seventh Circuit case, so this took place up north, up in Wisconsin. But in this case, there was a parochial school that they had their Friday night, they had their football games on Saturday because they didn't have lighting for their football field. And they applied for a general lighting permit so they could have Friday night lights essentially. And the city denied it and they appealed and they said, hey, all of the public schools have lights and we're not allowed to have lights. So this is infringing on our freedom of religion, freedom of exercise. And this is our LUPA case. So this is federal law protecting religious land use. And the court said, no, they're not, it has nothing to do with your religious mission that they denied it. It's because you're in a specific area where you're around a lot of residential housing. We don't want bright lights shining into these people's back windows. And said they're allowed to deny that. It has nothing to do with religion in this circumstance. And just because all the other public schools have Friday night lights doesn't mean that we're imposing on your ability to have free exercise. You can still have free exercise even if you can't have football on Friday nights. So just as a reminder that you always have these federal statutes, freedom of religion, our LUPA, Fair Housing Acts, kind of things just keep in your back of your mind when these cases come before you.
I think there are a lot of people who would say football is religion.
I think this could, yes. If this had been in a different part of the country, I think that we would have said it's Friday night lights is religion in every meaning of the word. All righty. Well, that's all I have for you guys tonight. I'd be happy to answer any questions either now or in the future. But thank you.
Something to read this week. My reading.
Anything else for the cause? We're adjourned. Thank you.